Good afternoon. My name is Hae-sun Kim, advisor of Gangnam Labor Law Firm. Today, with Labor Attorney Jung Bong-soo, we will cover the Article 93 of the Labor Standard Act, which is the rules of employment. So, could you define the terminology of this Article 93, please?
Okay. Hello. How are you today? This is Bong-soo Jung, Korean labor attorney. Today I'd like to explain the rules of employment that is stipulated in the Article 93 of the Labor Standard Act. So when employer hired 10 workers or more, must establish the company regulation named the rules of employment. It must include the working condition and service regulations. So also employer should report it to the labor administrative office. So what should be included in the rules of employment, I explained like service regulation and working condition. There are certain items stipulated in this Article 93. So first one is wage. So what compose in wage, also how to pay, also how to calculate overtime, also like payday. So they should be described in this company rules of employment. Also working hours, so starting time, ending time, also recess period, also annual paid leave, also holidays. They should be stipulated. Also other working conditions like prevention of workplace harassment and prevention of sexual harassment in the workplace. Also some the protection articles for female workers like maternity leave, child care leave, or other related the female protection leaves. Those items they are described in this Article 93. Yeah.
I see. So when an employee is employed by the employer, he or she needs to sign the employment agreement, and the employer should stipulate the rules of employment. And it's very important that the employer disclose the terms and condition of the rules, and the employee should sign.
Yeah.
Is that right?
Yeah. So in order to make rules of employment valid in the workplace, employer must obtain, also must show and must listen to their opinion in writing. Like even though it doesn't matter they agreed or not, but at least they must have their signature for reading and understanding what is the regulations. Also, when employer change the rule disadvantageously, then employee should obtain their consent of like consent of majority of workers, or the consent of employee representative. So this is a legal requirement. If employer neglect to have their opinions on change the rule or rules of employment, then this rules of employment is not valid. So it is employee's duty to make rules of employment unilaterally, but without their some like agreement or their understanding of this rules of employment by revealing it to them. So it is very much required. Without such a process, the rules of employment cannot be valid. So like employee should make rules of employment first, then it must open and must show the rules of employment, and all workers read and understand. Then that is company can be a company regulation. So in the beginning it's acceptable, but when employee changed such rules disadvantageously, then employer should obtain their agreement from majority workers, then this change the rules, change the rules of employment can be valid. Yeah.
I see. So this Labor Standard Act only specify the minimum requirement or what should be included in the rules of employment, and based on these items, the employer should make a detailed list of rules of employment. Is that right?
Say again, you catch. I'm sorry.
So the Labor Standard Act stipulate like 12 or 13 items that should be included in the rules of employment. But this is the basic requirement, and the employer should give a detailed description of the rules of employment.
Yeah, that's right. Usually company can have the rules of employment that include about 50 articles or sometimes maybe 100 articles. So according to Article 9.3, there are certain items must be included in the rules of employment. So employer should describe those working conditions in writing. So this is a very important requirement. Then it can be regarded as a company's kind of standard rule, or we call it rules of employment. So this is those items must be stipulated, and also when they filed these rules of employment to the labor office, then labor inspector checked these rules of employment, whether the required items are included or not. So if some items are missed, something like female protection rules, then labor inspector give us some correction order for what they reported. Then like labor inspector wait until those correction order is maybe changed or accepted. So that means rules of employment must include those required the working conditions. Without that, like the rules of employment cannot be accepted as a company regulation.
I see. So I understand that Gangnam Labor Law Firm has been advising many companies about these rules of employment. So could you explain briefly about the case where the employer and employee had a dispute because of the rules of employment was not well disclosed?
There is one typical cases I represented for a particular employee. That employee who was a sales manager working for a very famous newspaper company, the Wall Street Journal. It's been almost 10 years. So the sales manager told me when he joined this company, they promised to pay 2 months the monthly salary for each service a year as the name of the severance pay. So he was pleased to know that, but after working 10 years, in the middle of his employment, the company changed the rules without their obtaining the agreement. Then company decided to pay 1 month's salary each service a year for severance pay. So employee was not happy about this. So when he resigned, he visited my office and assigned me for his the labor attorney, and I filed this case to the labor officer, and I explained the company changed the rules of employment without obtaining agreement of majority workers. So the reducing some severance pay from 2 months to 1 month without employees' agreement cannot be valid. So company must pay retroactively for lost paid severance pay. So labor inspector agreed with me, and they gave correction order to the company. So employee could receive 10 months additional salary thanks to my successful role.
I see. Thank you very much for your introduction. Very interesting.
Okay, thank you for watching. Bye bye.